My name is Sarah Wynne Williams, and I served as the Director of Global Public Policy at Facebook, now Meta, for nearly 7 years, starting in 2011. Throughout those 7 years, I saw Meta executives repeatedly undermine US national security and betray American values. They did these things in secret to win favor with Beijing and build an $18 billion business in China. We are engaged in a high-stakes AI arms race against China. And during my time at Meta, company executives lied about what they were doing with the Chinese Communist Party to employees, shareholders, Congress, and the American public. I sit before this committee today to set the record straight.
We've seen them be willing to give away American user data, but they were also trying to find out a way to make a buck on Americans, teenagers, children in times of distress right here in the United States. This is about Facebook's program to target ads to people when they are in emotional distress. Is that right? Is that what we're seeing here?
That's correct, Senator.
And that included teenage girls, as you were discussing with Senator Blackburn, those who had maybe recently deleted a selfie, maybe not feeling very good about themselves, and Facebook said, oh, fantastic opportunity. We could sell this to advertisers. It apparently also included young mothers who are in moments of distress.
Imagine sitting on a stage for an hour, unable to speak, nod, or even shake your head. This was the shocking reality for Facebook whistleblower Sarah Wynne Williams. Meta secured an emergency legal order to stop her from discussing her book, Careless People. One single breach could cost her a staggering $50,000. Her memoir alleges a toxic internal culture, political manipulation, and terrifying concerns regarding the well-being of child users on Meta platforms. Critics are calling this trolling-like behavior and pure censorship, arguing that tech giants now wield power like despotic nation-states.
I'm going to ask you to leave. I'm going to ask you to leave the studio. This is the lawyer writing to us now. I must ask that you refrain from engaging in any conversation about Meta or Ms. Wynne Williams' book during her appearance on the podcast. I actually can't believe I'm saying this, but in order for us to have the conversation now, I'm going to ask you to leave. I'm going to ask you to leave the studio because you cannot be present for the conversation that we now need to have.
Okay.
Help us piece together now. What the fuck is going on, frankly? Because this doesn't feel normal.
To all units, proceed to your post assignments. All units, proceed to your post assignments.
That's the sound of the police. Whoop, whoop. That's the sound of the beast.
Yeah, baby, it's episode 38 of Probable Cause on July 7th, 2026. Jeff Norman and the FBI whistleblower himself, Greg Dillon, with you, as we always are on Tuesday nights. And tonight we are very pleased to have with us Arkady Itkin, an employment attorney based in the great city of San Francisco, California.
Hello, everyone. Thank you for having me.
Thanks for coming, sir. And as I mentioned, Arkady is an employment attorney, and we are going to discuss the Sarah Wynne Williams case. In the opening video, you saw that there's, well, I guess you could gather from the video that she has a gag order imposed on her, and so does her attorney. So we have Arkady, who can, there's no gag order imposed on you. I forgot to check that just to make sure. You are free to speak?
Yeah.
All right. Because I know that Meta's tentacles are far-reaching in your part of California. I sent Arkady, the latest is that Sarah Wynne Williams filed a lawsuit claiming that the gag order imposed upon her is illegal, and I sent Arkady the complaint. This lawsuit was filed just a few days ago, and Arkady replied by asking me who he should bill for reading it. And I told him the same person that I bill.
Jeff,
Good
I'm
luck.
sorry. I just got a text message that says that Arkady's going to have to leave this podcast right now.
Wow, Meta is powerful.
That didn't take long.
Right. Well, let's set the stage a little bit. Well, first of all, we have a sponsor now, Arkady. Did you know that?
No.
Arkady used to co-host another podcast with me a couple or so years ago called Scenes from the Evolution. And now we have a precious metals sponsor called Goldco. Are you, do you own any precious metals?
Yes, sir. I actually have some in my office now, too.
Very good, then. Well, you can just chime in and encourage folks to go to probablecause.gold. From precious metal IRAs to direct purchases of gold and silver, Goldco has helped thousands of Americans diversify and protect their retirement savings every day. In fact, Goldco is the #1 rated precious metals company in the nation and has earned more than 8,000 five-star customer reviews for trust, transparency, and service. You can request your free gold and silver information kit right now at probablecause.gold. And when I say you can do it, what I mean to say is you should do it. Is it a bullish or a bearish market now, Arkady? Are you following the situation?
You know, I do believe that everything is overinflated when it comes to AI. I'm in the middle of this whole AI thing. Everything is over-leveraged. All the companies have over-borrowed. Eventually, it will collapse. And one obvious reason to invest in gold and maybe other assets is to have some kind of cushion when things inevitably and necessarily deflate. It's coming.
Right. All right. You heard it from Arkady. And he lives in San Francisco, so he knows what time it is. He knows which way the wind blows. Don't be like Greg Dillon, who won a $1.5 million settlement. And what year was it? Did we finally get that clarified?
You were correct. It was 1999.
Right. So it's tonight. It shows about a whistleblower, this woman that we're talking about, Sarah Wynne Williams. But little did you know, Arkady, that Greg himself is a whistleblower. And I recommend his book, The Thin Blue Lie. He sued what was it? The Connecticut Department of Attorney General.
Office of the Chief State Attorney.
Office of the Chief State Attorney. And he got a settlement of $1.5 million and did not, at that time, invest in gold or silver. And I told him if he had invested just $10,000 at that point, today that would be worth, let's check it, let's run it through the special calculator. If he had done that, today it would be worth $1 million. Unbelievable.
In my defense, Jeff, I'm so old that they had not yet discovered gold and silver when I got that award.
All right. Well, anyway, there's no time like the present time. You can catch up and get off that window ledge. Don't jump, Greg. Life is worth living. All right, so let's set the stage, shall we? This woman was the director of public policy at what was then called Facebook. Facebook is now a division of Meta. She worked there for 7 years, and she was fired in 2017. According to her side of the story, it was because they caught wind that she was being sexually harassed, and there was a complaint coming forth, and before she could provide all the information about that, they fired her. And according to her, pressured her to sign a non-disparagement agreement in exchange for giving her $780,000 in severance pay. And she says that she signed it under duress. And I guess that's enough to just sort of give people a sense of it. We don't want to go too far into the weeds right away. What's your general sense of this case, Arkady?
You know, this is a classic 50-50 sense. So let me first address what you mentioned. First of all, I take issue with duress here. The fact that somebody needed money, that alone does not establish duress. Even if she had kids, she had some health care that she could not afford stopping to provide. She signed the agreement. She signed the severance agreement. It falls far short of duress. So my sense is that the Meta already filed a motion to compel arbitration, in which they're saying after all these months of arbitrating, all these restrictions on her speech back and forth, now she's coming to court. No, it has to go back to arbitration. It's a tough case, and it's a mixed case, because some of the things that she wants to share, she's allowed to share because these are violations of law. And some of them are very personal, her personal impressions of what her coworkers were doing and what was going on, which I believe she's lawfully precluded from speaking about.
Right. Well, let's look at, I'm not sure if this speaks to exactly what you just said. She said that, well, let me just read it. When Meta later made public statements that it would, quote, do the right thing and no longer force employees to arbitrate claims related to sexual harassment or sign non-disparagement provisions preventing discussions of unlawful workplace conduct, Ms. Wynne Williams took Meta at its word, and she began to disclose the unlawful conduct she saw while at Meta to the Securities and Exchange Commission, the Department of Justice, and to Congress. Having made those public disclosures in March of 2025, Ms. Wynne Williams published Careless People, A Cautionary Tale of Power, Greed, and Lost Idealism, a memoir of her time at Facebook, laying bare the truth about the company and the people who run it. All right, so that doesn't really speak to the duress issue, but assuming that this is truthful, this is from the complaint that from her lawsuit just filed a week or two ago. Assuming that's true, could that potentially get her out of the non-disparagement deal if they said, hey, we're not going to enforce this?
Well, there's a couple of unanswered questions here. First of all, what exactly was the statement? Secondly, was it made, at what time was it made? Was it made retrospectively or only prospectively relative to when she signed the agreement? We're talking about disclosures to Securities Commission versus the disclosures of sexual harassment. I'm not so sure that this applies to her, that this commitment not to enforce arbitration agreement applies to her. And I do think it's an issue for her. The courts don't like it when you act like the arbitration agreement is invalid. It is valid. You act like it's enforceable. Both sides go to arbitrator multiple times on a variety of issues, and then over a year later, they say, oh, this arbitration agreement is invalid. It might be an issue.
All right, what else do I have? Greg, you want to jump in here?
I'm just wondering, would she have been safeguarded or protected if she confined her remarks to her testimony before Congress and the Security Exchange Commission and did not write the book? Would that, do you think, have changed the outcome of what's happened?
Absolutely. At least in California, no agreement, even if you sign an agreement, can prevent you from truthfully testifying pursuant to subpoena. So you can sign any document in the world. You can receive as much severance as you want. You get a subpoena, not only from the government, from any legal case, you're allowed to say whatever it is that you ask.
So she crossed the line with the book, I take it. That's it?
Depending on the contents of the book, yes.
Okay.
There's a federal statute that protects whistleblowers who want to complain about sexual harassment. So basically, as I interpret this, I don't know if you can see that, Arkady, I think what this means is that it's just not enforceable if there was sexual harassment. I mean, you can, I guess maybe you can explain the difference between a non-disclosure agreement and a non-disparagement agreement, but I guess either way, it doesn't prevent somebody from making complaints about sexual harassment, correct?
Right, and here it's a little bit different. Can the employer prevent you from speaking about it once you settle your case versus going to arbitration versus to court, right? But yes, nobody can force you into arbitration of these types of claims.
Right. You know, I guess I don't know if I'm able to pull up the complaint right now while we're talking, but I was kind of flip-flopping back and forth about whether I was, because I'm a big free speech guy. So my initial reaction was, oh, fuck Meta, this woman deserves to speak. And then I said, oh, well, she signed this agreement. And then I started swaying to Meta's side of it. But then when I read her complaint and I saw some of the specifics, then I got swayed back there. I guess that's how it goes. I once read an article that gave I forgot what the percentage is, but juries in general, when they hear one side give an argument, they tend to believe that side. And then when they hear the other side, then they just flip to that side too. Yeah.
That's
Arkady,
why I
just
always.
for the benefit, I'm sorry, for the benefit of our audience, could you just briefly explain how arbitration is different and distinct from say a civil proceeding or a lawsuit?
Me, right?
Yes, please.
Okay, of course. So arbitration, the whole idea behind arbitration is a private process. You don't submit your case to court. You submit your case to a private arbitrator who works at a private company. And this could be a former judge. Usually it's a former judge. And he makes all the decisions. The process is quicker. It's more streamlined. There's less steps. There's less discovery. The reason that employers like this, well, the reason is twofold. Number one is that arbitrators are known not to throw a bunch of money on people for emotional reasons, because they feel sympathy for them, because there is a significant emotional distress element like the jury would. So you very rarely see huge awards by the arbitrator. Secondly, arbitrators, not all of them, but many, if not most of them, are known to be biased in favor of employers, because that's where they get their business from. Large firms keep coming back to them with arbitrations, with disputes. So for them, if they nail an employer once, and that employer is represented by a huge employment defense firm, that employment firm is probably not gonna come back. So it's an uphill battle to win. And if you win, you're likely to win much less than you would in court as a plaintiff.
But that triggers my next follow-up question, which would be, how are arbitrators selected? I mean, do both sides have to mutually agree that they're happy with the person because they feel they are neutral and fair?
So normally, you have AAA, American Arbitration Associations, and we have GEMS here, Judicial Arbitration Mediation Services. When you ask for arbitration, they send you a list of people. You can cross out a couple of names. You're left with a few names. You should try to agree on an arbitrator. If you don't, both sides cross, and then they arbitrarily pick whoever is left in the list. Both sides, the plaintiffs and the defense, have their own databases, their own online sources where people provide feedback about who is fair, who is not. So that's how it works.
Okay. All right. Because that sounds like it'd be a whole sort of a legal battle in and of itself, just trying to select an arbitrator that both sides are happy with.
Absolutely, because in many cases, who the arbitrator is can really determine how especially when it's a 50-50 situation, which many of them are.
Okay,
Yeah.
Thank you.
Of course.
All right, I just found the complaint. Let me see if I can bring it up on the screen here. All right, well, I'll just read it out loud. This is her argument about signing under duress. To compel Ms. Wynne Williams' continued silence, Meta insisted that she sign an agreement with a mandatory arbitration clause and a broad non-disparagement provision that purported to prevent Ms. Wynne Williams from engaging in any disparaging, critical, or otherwise detrimental comments about Meta and any of its executives and employees. Meta made executing the severance agreement a condition to Ms. Wynne Williams' ability to submit for reimbursement over $300,000 in pre-approved business expenses she had paid using her personal funds, including luxury hotel rooms and other travel expenses for Mr. Zuckerberg and fellow Meta executives. Those expenses remain unpaid. And then it goes on to talk about she needed the health care coverage, and they also threatened to take away. But is there a distinction, Arkady, to be made between what you're getting in a severance agreement, which is a new situation, and assuming it's the truth, that they already owed her, aside from any severance agreement, they already owed her the $300,000. Could that be an argument that she was signing under duress?
I don't think so. And my best guess, not because I'm on Facebook sites, I'm just saying, my guess is that there was a dispute over how much they owed her, whether those were necessary and reasonable expenses or not. And they told her, hey, we don't know who is right and who is wrong, but if you sign this agreement, if you agree to all this, we're going to give you severance and we're going to give you the expenses. I still don't think it's being forced, and I don't like these arguments that are overplaying their hand. Unless somebody put a gun to her head and forced her to sign this and pay her, this is still not duress in my view.
Arkady,
Got it.
just out of curiosity, do you know if she had legal representation during this process, or was she trying to navigate this on her own?
I think the complaint talks about her doing things through her attorneys. I believe most of the time she did. I don't think at the time she was signing severance she had attorneys. I don't believe so, but I'm not sure.
Okay, just wondering.
So you don't like the duress argument. Is this an argument that people make a lot?
I don't like several arguments in this complaint that are overplaying their hand. If you're saying duress, you better then show me something that says, hey, you have 1 hour to sign it and you're not leaving this room until you sign it, or something like that. Anything short of that, a high level executive.
No, but I'm not asking. But I'm not asking you to evaluate it in this instance. I'm asking you if duress arguments are common or not.
I think most people are cautious because they know the standard is very high. You only make it when you mean it. Not very common, because most of the time here you can consider it. Come back, tell us if you agree. Not very common.
Right. So I guess the average person out there may not be totally familiar with what sort of cases you deal with as you're an employment lawyer, or a labor attorney is another way to describe it. What would be an example or two of the most common types of cases that you handle?
Okay.
And which side are you on? Are you on either side, or?
I'm on either side, and my advice to everyone, if you want to be a good landlord, be a tenant. If you want to be a good plaintiff's attorney, represent the defense. It helps so much. People who swear by only representing the other side, I think they're limiting themselves and they're limiting their abilities. But retaliation is very common. They say revenge is a very strong, fundamental human instinct, right? So an employee complains to HR about his boss, and then the boss comes up with some bogus reason or not bogus reason to terminate that employee. Disability rights violation. Somebody is asking for an accommodation at work, maybe a special chair, maybe a keyboard, maybe frequent breaks, maybe medical leave. And then the employer doesn't like it, and they maybe come up with reasons to get rid of that employee sooner or later. Age discrimination is very common, hard to prove. People want to replace older people with younger and cheaper people. So, yeah.
You were telling me that right now you're handling a case, you're representing somebody who worked for a public agency in San Francisco who was fired for misgendering somebody. Tell us about that. How did the misgendering happen? Was it a one-time thing, or repeated, or what exactly?
Okay, so we can all imagine you work with someone and you're used to them being of one gender, and then one day they come back and they say, this is my new gender and my new pronouns. Out of habit, you're going to continue calling them the gender you used to. And if it happens over, let's say it happens half a dozen times over a period of 2-3 years, and that employee runs to the management in the place like San Francisco, where it's such a big deal, harassment, and then that employee is up for termination. The decision has not been made, but the mistake he made there, and it's a very common mistake among witnesses in criminal and civil cases, is exaggerating, making things sound better than they were. So,
well, hold on. Before you get to that, what was the misgendering exactly? Was it a one?
Instead of calling they them, calling him he she, or he him, instead of calling them they them. After they
and this person is a biological male.
Correct.
And instead, I would have thought it was like a what do you call it, a transgender thing. This is even more ridiculous. So this is a male who wants to be referred to as they, and your client referred to him as he or him,
and sir a few times after the transition or whatever, after the pronouns, referred to him sir, and a few other relatively benign incidents.
But Arkady, excuse me, because I'm ignorant in this area. If someone wants to be called this neutral they or them, what would be the equivalent of sir or ma'am?
Just not saying anything. Just
no,
not
saying anything. My point is like you say him his is wrong, or her she her is wrong, but that in between where what is the word that they would be happy with for that?
I think the answer is there is no known substitute for sir.
Well, there's name. You can
Yeah.
call them by their name or nothing.
Yeah.
But when you refer to them in third person in front of someone else, then you have to say them, they.
How about you? I guess you can get away with you.
Of course, you can.
Okay.
So about how many instances of misgendering were there approximately?
I will probably redact the document and send it to you. But if I remember correctly, maybe over the period of 3 years, maybe five, six times or so.
That is such a nothing case. And they fired him for this. Jesus.
Well, he's up for firing. Yeah, he's up.
What?
Not fired yet, but yeah.
Oh, they didn't fire him. So what's the problem then?
It's been recommended. There's a recommendation to dismiss him has been made. So we have a hearing on Friday where I'm going to appear and I'm going to challenge that.
Oh, okay. All right. So I interrupted. You started to say that the case got complicated because your client maybe told something slightly less than truthful.
Right. So I don't think he would actually be up for dismissal because an investigation was conducted and he was asked if you ever misgendered. And he said, never, never, ever, ever. And then a bunch of witnesses said that it slipped a few times that he did. And now this whole thing calls his credibility, his veracity into issue, and not being truthful alone, even if the underlying violations are not serious, that alone led the agency to try to want to dismiss him.
Okay, because he said it never happened as opposed to a few times. Yeah.
How many hours do you think have been wasted on a nothing burger like this?
Oh my God!
I mean, when you factor in the investigation, when you factor in your involvement, I'm just thinking, like, how many hours are we going to waste on something so trivial and ridiculous as this?
Guys, if you only knew, not only countless hours on stupid investigations that last for hours about nothing, where lawyers are paid $800 an hour or more, God bless them. Some of these people who are accused, especially in public agencies, are placed on paid administrative leave pending the outcome on investigation for months or even longer. Okay? While all this is going on.
Yeah.
Or I don't want. I mean, you seem like you may not want to reveal too many details about this, but this is a public agency. So is this in the news in San Francisco or not?
I don't think it's a big enough case. I wish it was, but I think I'm gonna send you everything. I'm gonna confirm. I'm gonna actually ask my client if he's okay with me sharing, and I'll share everything with you. I don't think it's gonna be confidential because yes, it is public information.
All right. Oh, do you want to say what the agency is now, or you don't want to say?
What the agency is? I actually forgot.
Oh,
and here's a messed up part. They've been separated. They haven't been working together in over a year. And my guy, no problems ever since with anybody. No issues at all. And only now, they're trying to dismiss him when everything has been fine for a year.
And this is just political theater is all it is.
So because they're overprotecting, and this is a sanctuary from transgender people, and God knows who makes the decisions in charge, maybe they're obsessed with this issue because all it takes is one person to take it too far, right? Mm-hmm. They're overplaying it, and this really sucks.
All right. Well, if anybody needs your services, they can go to your website, arkadylaw.com, arkadylaw.com, ARKADY law.com. And you, sir, can skedaddle if you want, but if you want to hang out with us, we're going to do Has It Happened to Greg? What is your wish, Arkady? The time to decide has come.
My wish for?
Do you want to hang out with us for Has It Happened to Greg? Or
yes, I will hang out with you for maybe another 10, 15 minutes, if that's okay.
Arkady, just so the audience knows, what areas of law do you practice in addition to employment and labor law?
Business litigation and personal injury, again, representing both the plaintiffs and the defendants.
Okay.
Thank you for asking.
Yeah, sure.
How often, like in this particular case, the argument is that Meta is violating her First Amendment rights. So I'm not saying, I don't know whether you know or don't know a lot about First Amendment law. I'm asking a somewhat broader question, Arkady. How often does it happen where some area of law that you're not specializing in somehow intersects with the case? Is that a problem, or how do you deal with it?
Absolutely. Absolutely. It comes up all the time because, like you guys said, if somebody works at a public agency and they're punished for saying something, punished for expressing on a matter of public concern, these cases come up all the time. Somebody put a Free Palestine thing in their office. Makes a difference if it's a public agency or private. What the internal policy. Somebody posted something on social media and it said there was recently a case when settled for a lot by a professor who was talking about genocide, Israel and all that. And she got 1.9, I think in Tennessee or Connecticut. No, in Tennessee, a professor. That would be an interesting case to talk about. And she was saying bad things about Israel. She was reprimanded. She was dismissed. She was removed. I think her tenure was revoked. She settled her case for 1.9 on First Amendment, employment and First Amendment and won.
So if you were representing Sarah Wynne Williams, or Meta, you would need to know about First Amendment law in order to deal with this argument, right?
Absolutely. This is just one of the arguments they make, right? But yes, you better know what you're talking about defamation as much as you do about arbitration, enforceability, and First Amendment, among other things.
So if you don't have this, if you go ahead, Greg.
No, it's not unusual though to collaborate with another attorney who's an expert in that one particular area, correct?
And I'm suspecting that since we have half a dozen attorneys here on this case from Washington, D.C. and from New York, I imagine some of them specialize in something more than others, right? Look at all these names.
Wow.
Yes.
Yeah, that's an expensive litigation.
Mm-hmm. So in some cases, I would imagine you would need to confer with another attorney, and in other instances, you would just have to educate yourself about an area of law that you don't necessarily know already. Yeah.
Absolutely. Ideally, you would have some prior experience with something similar, at least somewhat.
All right. Let's go to Has It Happened to Greg? This is when we show police videos, videos of police encounters that are circulating on the internet. And we ask Greg if anything like that has ever happened to him. And we just give our comments about it. So jump in with any opinions you might have, Arkady. And the first one is, I know it's going to make Greg's blood boil seeing this. Take a deep breath, Greg. You're not going to. So they just took it. These revelers, whatever we want to call these fine New York City citizens, throwing water on the cops, and they just simply endured it. I found this on Facebook, and a lot of the comments were saying, "Oh, they weren't upset. They were, playing along with it. They were okay with it." I don't think so, though. If you had been out there and they threw a bucket of water on you, and then you had to work the rest of your shift drenched, would you think that's just good fun?
Well, in today's environment, I would make it a point of retrieving as much video camera surveillance footage that they have in the area, from street cameras or body cameras. Circulate the photographs of every person that shows up on the video, and make an attempt to identify them through other police officers and circulate it throughout the station, and then just get warrants for every one of those people and then pick them off one by one. Once the word gets out that they follow up on these things, then all of a sudden it won't be as much fun.
Now, could the cops have opted to do anything in this situation? I mean, why do you suppose they just endured it?
It depends on the disposition and temperament of management there. If this has happened before, and the strategy is to not escalate these things and to just retreat, then they're doing what they were told to do. But I think what they need to do is make it a point of identifying the most egregious violators there and get arrest warrants for them, and then put bonds on them, and then go out and pick them up at their home in the middle of the night and send a message. Doesn't have to get rough, just has to be effective.
Arkady, I used to tease you about San Francisco and refer to it as the feces capital of the world, or capital of California anyway, because it's known for having human feces strewn all over the place. I've been reading, though, that I guess it's the new mayor is doing a good job and things have been improving.
Yeah.
What about something like this? Does the community respect San Francisco cops? Would anything like this happen in San Francisco?
You know, one of the advantages of living in a very expensive place is that you don't have that demographic all that much in San Francisco, right?
Oh, what an elite, what a snob you are.
That's one of the few advantages. I don't think they might be dealing, but I'll tell you, I can totally read their mind. Should I put on some kind of show and arrest these people, be in the news, be suspended, be accused of racism, lose my career and pension, or maybe end up in jail if it escalates in the wrong direction? Or should I let a little bit of water on me? I'll suck it up and I will walk away and everything is fine. No injuries, no issues, right?
Yeah. There was, I think we even showed the video here, Greg, correct me if I'm wrong. A few months ago in the winter, they were throwing snowballs at the cops.
There was a park in New York, yeah.
Right, and didn't they make a couple of arrests?
Oh yeah.
Yeah.
Of course, snowball could, damage your eye. It could, if there's a lot of ice involved, it can really, give you a concussion or cut you. The water's a little bit of a different story, but
what do you mean? It's torture. It's waterboarding.
Well, but the thing is, now you've taken that unit out of service for the next, hour or two, while they have to go back to the station and change into dry clothes. So there's an impact there. I mean, it's not bodily injury, but it's costing the city, whatever it costs to take them out of service for a couple of hours, and plus it sends a very bad message that you can do something like that and not have any consequences. There need to be consequences for that type of action. And when I say consequences, I'm talking about getting arrest warrants and going out and tracking those people down one by one, bringing them to the station, putting a bond on them, making them go to court, and hopefully a judge will treat it with the seriousness that it deserves. It's not a prank. It's not mischief. It's a criminal violation.
Right. Yes, I'd like to call on the gentleman raising his hand, Arkady.
Yeah, and just like Greg, I hate impunity. And I am actually glad that the people who blocked Golden Gate Bridge for Palestine for several hours, they were convicted by jury, and they're going to be sentenced to something, whatever that is. And there should be consequences.
Absolutely.
Like running them over would be a good consequence.
Yes.
Is it routine for cops to have another uniform that's dry, just ready to change into?
Yeah, everyone usually has a locker, and in the locker there's going to be, hopefully, because they get a clothing allowance, several pair of trousers, several uniform tops. Oh, okay. Because you never know when you're going to get a lot of blood on your clothing, or like in this instance, water. If you get into a foot chase and you're covered in mud, you can't work the next 5 hours.
Or feces if you happen to be a San Francisco cop.
True.
Who pays for the cleaning?
Routinely, the police departments do.
Right. Okay, that seems fair. All right, let's take a look.
City of the town,
Let's take a look at another instance of somebody challenging police authority, but this is in a much different context.
Really quick?
Sure.
How are we getting a ticket for speeding if we were following you and your lights were not on?
Because I was trying to catch up to somebody.
But your lights
And why
were
you
on.
following me?
I'm saying you were in front of us and your lights weren't on, so we were going your speed. So how are we getting a ticket? Because your lights were
you're
on.
speeding.
But that means you were as well.
That's because I'm doing my job. I'm allowed to do that.
Without the lights on?
Okay. Is that it? I guess that's all there is. I thought that was longer. All right. I don't know what happened. I thought that was longer. Something happened. So she was following them. How could the cop? Obviously, it doesn't get her off the hook because the cop might have been driving illegally. But how could the cop have determined that she was speeding if he was in front of her?
Because the speedometers are usually verified. So you can track. The reason they do that is so that you can track a car ahead of you normally. And if your speedometer shows 90, you've had it calibrated, so you know it's within a mile. You know, it's 89 to 91, say. So you write the ticket for 90, and your evidence is you visually saw your speedometer at 90 for over the course of a mile or two, and therefore the person in front of you, assuming they're traveling at the same distance from you.
No, behind.
No, but same thing. Yeah. So I had one of my buddies. I used to have an undercover Grand National. I don't know if you remember the Grand Nationals, but they were like muscle cars, and no one would ever believe it was a police car. And he would drive on the highway, and usually it was to catch up with someone. But in this instance, someone was tailgating him. He brought the speed up to like 95. The person stayed behind him. After 2 minutes, he pulled over, let the car go by, pulled him over, and wrote him up the ticket. The person was trying to challenge him, saying, well, you were going as fast as I was going. And he said, I was doing that to see how fast you were going to drive for how long before I decided to pull you over and give you a ticket. And the judge was fine with it.
All right, I get it. So the cop looks at his speedometer, looks in his mirror, and if the car behind him is either keeping pace with him or getting closer, that's the proof.
Yeah.
Okay. You know where I thought this was going to go?
In front or behind, it wouldn't make any really difference as long as the distance stayed reasonably close and the speed was high. You know.
Let me try to play this again because I think there was something.
Really quick.
Sure.
How are we getting a ticket for speeding if we were following you and your lights were not on?
Because I was trying to catch up to somebody.
But your lights
And why
were
were you
on.
following me?
I'm saying you were in front of us and your lights weren't on, so we were going your speed. So how are we getting a ticket? Because your lights were
you're
on.
speeding.
But that means you were as well.
That's because I'm doing my job. I'm allowed to do that.
Without the lights on?
Okay. So, Arkady, Greg always accuses me rightly of being obsessed with citizen arrest authority. And I have carefully, I'm sure you have not bothered to familiarize yourself with these statutes, Arkady, as I have, because you have a life, you have a career, and I'm crazy. But I've actually researched this, and according to my amateur analysis, a person in California is actually authorized to make a citizen arrest of a police officer. So I thought, when this video first started, I thought that may be where it's headed. I mean, the cop said he was doing his job, but what does that mean? You're not allowed to exceed the speed limit unless you are in pursuit of a suspect or responding to an emergency, correct?
Well, first of all, I think there's a huge difference between theory and practice when it comes to citizens arrest. But I would imagine ambulance, fire, and police have a wide latitude in when they can speed, and their good word for saying that they were rushing for whatever reason is going to be good enough. They don't really need to justify why they're speeding to citizens.
I don't know. How can he say he was responding to?
If there was an undercover operation, right, and you were trying to tail a car, and the car.
Yeah, that's one of the exceptions I mentioned. It's okay to do it when you're pursuing a suspect or responding.
I'm not talking about pursuing.
Okay.
My scenario is you're in undercover capacity, and you are trying to surveil someone, and they routinely drive way faster than the speed limit.
Well, I would think that surveilling somebody is essentially the same thing as pursuing a suspect.
Pursuing would be to try to pull them over. Surveilling is to keep them in sight without making a stop.
Well, it's a legitimate police duty as opposed to when you're just doing routine patrols driving around and it's not necessary to go through red lights or speed. That's the point.
Correct, but he said he was trying to catch up with someone and he noticed them in his rearview mirror.
Yeah, well, how believable is that considering he stopped to give her a ticket instead of the non-existent person he said he was following?
Well, don't say non-existent.
All right. This is our version of a lover's spat. In the interest of maintaining our good relationship, I'll leave it at that.
Okay.
We have two more videos. Let's take a look at the next one. This is a police. Reminds me. We showed the one about the cops who rescued somebody in the water. I'm like, geez, is that really what they're required to do? And then that other one we saw when there was a child dangling from the building, and so maybe we'll just let the kid drop. I'm not sure I want to risk my life. Here's one not quite that dangerous, but I guess this is under the heading of, is this really the responsibility of the police? Nonetheless, this officer took care of it.
In Wilmington, officer.
By the way, that's in my hometown, my new hometown of Wilmington. This happened, so just want to.
The boar whisperer over there. Going in arrest. No.
All right. I'm sorry.
In Wilmington, Officer Cook responds to a home invasion of a very different kind.
Reference to a raccoon inside of someone's house. Hopefully it's not like a rabid raccoon. I've already had to shoot one, so I'm hoping that's not what this is. And it's just a raccoon that found its way into a house and I can shoot it out. We'll go see if we can help this gentleman get the raccoon out of his house. You got a raccoon up in there?
I believe there's a raccoon in there.
Did you see it? Did you see one? Did you see it?
I see it.
All right, let's go look for it.
I'm fighting with it.
You were fighting with it? Is it mean?
He's right over there in that corner.
All right, let me go see. I don't see no raccoon. Where? Behind the toaster? There's a missing raccoon. I don't want to move the toaster. I don't want it to attack me. There ain't no raccoon back there. No, there ain't. It ain't back there. What's that noise? Is it like hissing? I'm scared. I'm gonna get jump scared by a raccoon. B-Dubs, you don't see a raccoon? It's a possum. It's a possum. It's a possum, man. Ain't no raccoon. It's a baby. I'll get him for you. You got a towel or something I can use for it, Ron? You got a towel? I ain't putting him in no bucket. He's precious. Where the towel? Can I use that right there?
Right.
Yeah. Just to pick him up.
No.
He's playing dead. He ain't gonna do nothing. You come get him with some gloves on. I know. Come on, Bubby. Let's get him outside. I know.
All right, enough of that. You get the idea. Hey, Arkady left without even saying goodbye. What is this bullshit? I'm going to file a complaint with the state bar. You're supposed to say goodbye. No, he told us he could only hang out for 10 minutes.
Yeah.
I guess that's okay.
Yeah.
So I don't even know. I guess raccoons are dangerous, but possums aren't. Is that what I'm to believe?
You know, I mean, I know. We had a stretch there in Brantford where they weren't rabid, but they had some sort of a sickness that was making them act rabid. And, you know, after they had been euthanized, they were tested and they said, well, no, they're not technically rabid, but they do have some sort of a bacteria like they pick up and it goes into their brain and makes them act, you know, crazy. They challenge you. They stand on the road and stare at, you know, at cars and stuff. So we would get calls like for stretches at a time, and then it would, you know, go away for some reason. I don't know why.
But is this really the job of the police? Don't they call it animal control or something like that?
Some departments, you know, if they're smaller departments, you know, have animal control like just during the day, you know. Or like not on weekends. I mean, it's weird. The smaller the town, the less resources and services they provide. Bigger cities will have animal control, you know, 24/7. Smaller towns will have them, you know, maybe only during certain hours or certain days, that type of a thing. So it's not unusual to get called for a bat in the house, for a raccoon in the chimney. Some officers.
And then are you expected to actually deal with that?
Well, you know, I'm not really.
It's a good thing I never went into the police profession.
That wasn't my forte either. I have a soft spot for animals, but I also respect, you know, not getting bit by one. So I'm not quite sure, but oftentimes they'll try to get creative. You know, if there's a bat in the house, they'll open up a window and try to get them out with a broom. Or if it's a raccoon, you know, they'll try to, you know, sort of shush them out of the house in a certain direction to get out the door, that type of a thing. But we're not lion tamers. I mean, that's a whole different thing. I mean, you see officers down in Florida sometimes will grab an alligator by a small alligator by a tail and drag them, away from the property.
Snakes to get in, right?
Yeah. It depends on how the person grew up. If they grew up in the country, they're fine with it. If they're city boys, they're going to be terrified of that.
I would just misgender somebody and get fired, so I didn't have to deal with it. Hey, let me just answer this question. Goth Pop, who's watching us on Rumble, asked, does Scott still come on this show? You're referring to Scott Ritter. We still do the show with Scott. It's called Ask the Inspector, but it's on Wednesday nights, and we stream to some of the same channels. So we're on Tuesdays, Ask the Inspector is Wednesday, and then we have a third show called The Whiners on Thursday nights. They all start at 7 o'clock Eastern time.
Speaking of misgendering, just before the show aired tonight, I received an email that Arkady was going to be on The Whiners tonight.
Oh, you mean the Substack thing? Well, we'll talk about that later. That's too complicated to address.
That's fine. Just want to.
Okay.
Yeah.
All right. And then lastly, we have this lighthearted police video from Juneteenth. How did you celebrate Juneteenth this year?
Just like June 18th and 20th.
I think I can read between the lines.
Okay.
All right. So this is some cops who are on duty at a Juneteenth event.
Last time we get funky. To the left. To the left. Take it back now, y'all. One hop this time. One hop this time. Right foot, 2 stumps. Left foot, 2 stumps. Slide to the left. Slide to the right. Crisscross. Crisscross. Chop, chop, real smooth. Keep it smooth, one more time. Let's go to work.
You're the partner to the left there, right? In this scenario, or to the right, whatever it is.
Yeah, yeah.
You would just be standing there going, "Oh, geez, don't rope me into this dancing."
To each his own. I won't make you not dance as long as you don't make me dance.
Fair enough. Fair enough. You're a problem solver. All right. I'd like to encourage the audience to buy Greg's book. You can get it at ustourofduty.org. The Thin Blue Lie tells all about his fascinating litigation. Unfortunately, spoiler alert, I gave away the ending earlier, but just forget I said that, because otherwise it's a page turner. I was on the edge of my seat reading this, actually. Great book.
Well, and let's not forget that there was a second federal lawsuit filed over the same matter within a few years of the first one. So don't give that one away.
Oh, no. Okay. I was wondering what your point is. I see what you're saying. All right. Well, thanks, Greg, and thanks to our beloved audience. As I said, tomorrow night we'll have Ask the Inspector here, and then Thursday night, The Whiners at 7 p.m. Eastern time. Thanks to our beloved audience. Thanks to you, Greg.
Thank you, Jeff.
You're welcome, and have a good night.